Thanks for joining me on Freedom is Scary. I believe we're at episode 23. It looks like we're live now, so let me begin with a quote. Now, one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. That's from 1761, and that's by James Otis in his writing Against the Writs of Assistance. That maxim that a man's house is his castle is older than our republic, and it's deeply rooted in our Anglo-American jurisprudence, our roots. As scholars have observed, this maxim protects all levels of society here in America, even down to, quote, the poorest man living in his cottage. It formed really the basis of the Fourth Amendment itself. So while everywhere else in our society, the Fourth Amendment rights that we used to enjoy in public have eroded. In cars, they've eroded. On sidewalks, in airports, in schools, everywhere else, they've eroded, except where? In our castle. Whether you live in Castle Grayskull or you live as a poor man in your cottage, you still pretty much have the same strength of Fourth Amendment rights that we originally had at the inception of our country. And that is rare in today's society because pretty much our individual rights have eroded everywhere else. And sometimes our rights, and so, depending on what state that you live in, your rights may have even increased in your home, such as the castle doctrines that certain states have passed, such as here in West Virginia, or as they sometimes call it, the stand your ground laws. Especially now in 2020, as I usually call it, the year of the Karen. But you know what? It's not only the year of the Karen now in 2020. It's also that year where pretty much the Second Amendment debate has ended. Most people who are honest with what they're seeing on TV and in real life and honest with themselves, they know that the debate is over. They understand that you can't depend on the government to protect you, your life, your liberty, your property, protect your businesses, protect your family. No, you're going to have to protect yourselves. You can't depend on the government to protect you. We all understand that now. It's my argument that more freedom is always going to be the answer, just like it was at the creation of our republic. What we need is not more police, more laws, more jails. We need just more freedom. That's it. This episode is about search and seizure in the home. If you watch the last episode that I did on search and seizure, it was primarily in regards to pedestrians and being in a car. And those, as I said, those rights have eroded a lot. And it's very complex and difficult to figure out what your rights are and what they're not when you're in a car or you're walking down the side of the road. But certainly in a car, they're pretty much, if they're non-existent anywhere, then that's where it is. It's in the car. You have very few rights. As a pedestrian, surprisingly, you have greater Fourth Amendment rights. But when you're in your home, that's when your rights are at the maximum. So that's what I'm going to be talking about. If you have questions, put them up. No guarantee that I can get to them, but I certainly will scan it. Thanks for watching. Barry, the Karen call saying you are growing marijuana or whooping a dog or too hard or arguing with significant other ends in the cops at your home, it seems like. Well, a lot of civil rights law begins with the Karen call. Karens have created lots of civil rights laws. Okay, comprehensive training is vital. That's absolutely right, Scott. And that's sort of why I'm doing this, is I think there's no downside to more people understanding what their Fourth Amendment rights are. or what their Second Amendment rights are or Fifth Amendment rights. But really, Fourth Amendment is the basis of everything else. And it's not really that complicated to understand the basic concepts. All it takes is, some minimal effort to understand. So if you have family members, forward them this video or videos like it. There are some good videos on constitutional law and the educational aspects of it at Hillsdale College, their YouTube channel. I actually like those videos a lot, and there's a lot of good YouTube videos where you don't even have to go pay for an expensive education to learn the concepts. You can do that for free. You have so many resources really in your pocket. What does AOW stand for? I'm not sure exactly where you're pulling that from. Oh, somebody's question about the ATF. Okay. AOW usually stands for, and this is not what we're talking about, but I think it stands for any other weapon. It's a BS classification that the ATF has used to criminalize certain configurations of firearms. It makes absolutely no sense, but that's not what this video is about. We're talking about search and seizure in the home. So the basis of all of this is the Fourth Amendment. As you probably know, it's the right of people to be the right of people to be secure, not searched, in their persons, houses, papers, effects against unreasonable searches and seizures. And with few exceptions, warrantless searches are per se unreasonable under the Fourth Amendment. That's United States Supreme Court case law, Katz versus United States, ever since 1967. At the core of the Fourth Amendment is the right of a man to retreat into his home, to be free from unreasonable government intrusion. With few exceptions, the question of whether a warrantless search of a home is reasonable and hence constitutional must be answered no. That's Kylo versus United States, U.S. Supreme Court, 2001. The basic concept that you need to understand if you listen to nothing else is that a search or seizure in the home, if there's no warrant, it's presumptively illegal. So searches and seizures which take place inside a person's home are presumptively unreasonable. And that means that they're illegal by default, according to the Constitution, specifically the Fourth Amendment. On the other hand, again, when you're outside your home, Fourth Amendment protections only apply where courts have found that you have what we jot down as REP, a reasonable expectation of privacy. So in a lot of places outside your home, you don't, according to the courts, have this reasonable expectation of privacy, such as bank accounts or your trash or the open fields surrounding your house, of which there's a lot of that in West Virginia, and so on. There's a bunch of different cases on what items don't get the Fourth Amendment protection because there's no REP. Excuse me. Are there restrictions on cross-gender strip searches of detainees? I honestly have no idea what the answer is to that question. Can an officer search a home and call it a welfare check? Well, as you'll see, the quote touchstone of the Fourth Amendment is reasonableness. And not that that helps much, but officers' conduct when it comes to entering a home or searching a home, you'll see, is always going to be judged on a fact by fact basis, case by case basis, using the totality of the circumstances. That's the phrase they use. And it's going to be judged for objective reasonableness. Reasonableness just means that's just what it means. What a judge or a jury a lot of times thinks is reasonable. And that's an objective standard. So it doesn't matter what the officer's specific motivations were. It only matters what the objective, good guy, cop, reasonable officer would know and would do under the circumstances. So always it's a fact by totality of the facts analysis, and it's always using the objective reasonableness standard. But the big thing is that there has to be a warrant. If there's no warrant, it's by default a per se unconstitutional search or seizure. Willie, it seems like the courts hold homes to be sacrosanct. They do. That's exactly the common thread that you'll find in Supreme Court case law and circuit court federal case law, that anything having to do with the house, there are a lot of great cases. There's wonderful language if you're drafting a brief as a lawyer for a home search or a home arrest without a warrant, because there's all these great cases talking about how your home is your castle and how important it is, and it has the strongest protections under the Fourth Amendment of anywhere else. And there's a lot of descriptive language that courts have used. So yes, if anything is sacrosanct to the United States Supreme Court, it is a person's home. All right, so searches of a home require a warrant. If they don't, then it's presumptively illegal. And kind of what that means is that the police officers then need to prove that what they did was legal because they met an exception to the warrant requirement. So they can do it, but they have to prove one of the exceptions. And we'll get to what those are. So searches, let's see. The standard itself is when an objectively reasonable, when a police officer has an objectively reasonable basis for believing that somebody inside is maybe threatened with injury, and therefore there's exigent circumstances and there's an emergency situation. So if there's a life or death reason to enter, they can enter for what's called exigent circumstances. And it's, again, an objective, reasonable standard. The other big one that gets used is consent, which is obviously an exception. The big case that describes what consent is called Shincloth versus Bustamante, U.S. Supreme Court, 1973. Okay. Richard, only pulling questions from YouTube viewers. No, I'm not. I'm trying to both talk and look at questions as they come along. So if you have a question, put it in and I'll try to get to it. Shincloth versus Bustamante, basically establishing consent as an exception to the warrant requirement in the home. There was another big case from 2011 called Kentucky versus King. But going back to Shincloth versus Bustamante, I mean, the basic standard is pretty simple. It just has to be a voluntary consent. So was the defendant's will overcome or overborne by the law enforcement officers in the situation? And it basically depends, again, on the totality of the circumstances. So did they really voluntarily make that consent, or did they not? Was there some sort of undue pressure put on them by the law enforcement officer? Were they promised something in exchange for the consent? If not, then maybe it wasn't voluntary. It's a factual analysis. Back to Kentucky versus King, that was 2011, U.S. Supreme Court. And they sort of clarified the standard and stated that, if consent is freely given, then it makes no difference that an officer may have approached the person with the plan of trying to get them to consent to something. So long as they're lawfully allowed, so long as the officer is lawfully where they're allowed to be, they can obtain consent, even if they kind of maliciously are trying to trick the person into giving them consent. Let's see. Vivan, you say out of your home, you mean beyond the bounds of your property, or are you talking about your primary dwelling? So this is sort of what they call curtilage versus open fields. So in the open fields around your house, of which we have a lot of in West Virginia, the farm fields around your house, around your farmhouse, those are not going to have the protections that you have in your home. Those are what they refer to as the open fields. Now, at some point, as you get closer to your house, the immediate area around your house, that's known as the curtilage to your house. And I'll get to this, but you do have protections from your home that extend to things like your front porch and the area immediately around your house. Now, where does that end? And then where does open fields begin? Those are factual disputes that the courts could decide based on the actual home that is in dispute. So it's not really an exception, but another thing that comes up in this context is plain view, where police officers can seize something that they see that appears to be illegal or evidence of a crime, so long as where they're lawfully allowed to be. And there's a couple other rules, but the main case for the plain view exception is Coolidge versus New Hampshire from 1971, U.S. Supreme Court. If the officer discovers incriminating evidence inadvertently, so if he didn't know in advance that this incriminating evidence might be there, he can seize it relying on the plain view doctrine. But it must be immediately apparent to him or to the reasonable objective officer that this was contraband or otherwise subject to seizure. Now, there was a 2012 case clarifying the plain view doctrine, United States versus Davis. No, I'm sorry. It was a Fourth Circuit case. It was a Fourth Circuit case, United States versus Davis. The officer must have been lawfully in the place where he was allowed to be. He must have had a lawful right of access to the seized items, and the incriminating character of the items must have been immediately apparent. So that was a Fourth Circuit case clarifying the Coolidge case from the Supreme Court. So there might be slightly different interpretations in different federal circuits. And I believe some of what has come about is, for instance, with cell phones. So even if they observe a cell phone in plain view, it does not automatically let them seize the cell phone and the digital contents of the cell phone. And as technology increases, we'll have more and more of those types of cases. If cops damage your home whilst conducting an unlawful search, can you sue for damages? Well, yeah, you can sue. You can sue if police officers have a warrant and the warrant is valid. You may not be able to challenge the warrant itself or the search itself, but you can challenge the manner in which it was executed. So you could challenge the scope or the duration of the warrant execution. And if it exceeds the scope or the duration, then you could also have a civil rights violation, even though they had a valid warrant. And that is how no-knock warrants are challenged. So if they're looking for something in the garage and it doesn't extend to the third floor of the house, and they go to the third floor of the house, you can challenge that. But it's all a reasonable standard. So if they damage something, generally, in my experience, they have been held liable for damaging it if it's something that was done unreasonably. But that's a good question. Now, if they get a no-knock warrant and the validity is upheld, and so they bust down the door as they were basically authorized to do in the warrant, it may not be something that you can get reimbursed for, and it may matter, on a state by state basis. It's not really a federal constitutional claim if it's just a property damage claim, but a lot of times they sort of go hand in hand as a damage as a result of a Fourth Amendment violation. Squint Fox, I appreciate that. Another question: do police have access to attorneys to get authorization before entering a home? Who defines what's a legal basis for a warrant? Well, that's a good question. It probably varies per jurisdiction, but a lot of times, law enforcement should always have access to the prosecutors to ask them what is lawful, what is legal for them to do or lawful for them to do, and what is not. And a lot of times they do get basically legal advice from prosecutors. And that comes up in the case law as far as when they can get out of liability because they're just following the advice that was given to them by prosecutors. And I've had this come up before. I think it's always a good idea for them to contact the prosecutors and ask them for advice on what the law is. And they can always rely on that as a defense if the prosecutors were wrong. But a lot of times they might have difficulty getting that from the prosecutors because they don't want to give them that specific advice, though the prosecutors have absolute immunity. So I don't see any reason why they wouldn't. But I will get back to that. All right, so the exigent circumstances exception to the warrant requirement, that's the big one. It's basically if there's an emergency. The main case is Brigham City versus Stewart, a U.S. Supreme Court case, 2006. It reads like this. An officer may enter a home without a warrant when they have a, quote, objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with injury. The need to protect or preserve life or avoid serious injury is justification for what would otherwise be illegal absent an exigency or emergency. The officer's subjective motivation is irrelevant, and an action is reasonable under the Fourth Amendment regardless of the individual officer's state of mind, i.e., their subjective stupidity or ignorance, as long as the circumstances viewed objectively justify the action. So like many other Fourth Amendment violations, even if what the officer thought he was doing was not justified, he was wrong about the law, he was wrong about the facts, even if a court looking backwards at it in 2020 hindsight, if they can see that it still would have been legal on other grounds, then it still is a lawful search under the exigent circumstances exception. So usually it pertains to an emergency, a physical emergency of some, there could be somebody that's in danger inside. It could be what sounds like a child choking to death, some sort of imminent physical danger. But it also has been applied to, and this is the more controversial side of exigent circumstances, is destruction of evidence. The first real case on that that you need to be aware of is 1990 U.S. Supreme Court case of Minnesota versus Olson that basically clarified or established the precedent that police officers can use the need to prevent imminent destruction of evidence as authorization or justification for a warrantless search of a home. Now, this case from 2011, Kentucky versus King, also discussed destruction of evidence, and it said, but the police cannot create the exigency by engaging in or threatening to engage in conduct that violates the Fourth Amendment. So police conduct must be reasonable. They can't create the exigency just for purposes of creating the exigency. And whatever other ideas they get, they still have to be reasonable, and it will still be judged on a case-by-case basis according to the facts. But if you're going into a house without a warrant, the facts, the police officer's facts, they need to be strong. They need to be strong. So as long as they're reasonable and strong, they might get away with it. But certainly a physical emergency is the strongest exception claim under exigent circumstances. As far as an evidentiary claim, it's got to be something very particularized. Like the guy said that he slammed the door and said he's going to flush the cocaine down the toilet. So it's not just a general concern about destruction of evidence. There's actual specific information about this individual, this home, that if he doesn't enter right then and there, if he takes time to go get a search warrant, that there's going to be imminent destruction of material, crucial evidence. So it'd have to be something like that. It certainly happens. Really, lastly, as far as exigent circumstances are concerned, is hot pursuit of a suspect, hot pursuit situation. 1976 case, United States versus Santana. And it's basically just like it sounds. If they're chasing a guy and he runs in his house, they don't have to just stop at the door and leave and go get a warrant. They can generally chase him right through the door if it's a legitimate hot pursuit. Somebody had a question about around the home. The good case for understanding this is the 2013 case of Florida versus Jardines, U.S. Supreme Court. That's where police officers took a canine drug dog around the front porch of this guy's house. So they're on his property, they're on the front porch, and the dog hit on something on the front porch. And then they used that fact to go get a warrant to search the inside of the house where they found drugs. And ultimately, the U.S. Supreme Court found that because they physically occupied his porch and searched his porch, they didn't have a warrant, nor did they have consent by the homeowner, that it was a search under the Fourth Amendment because they were occupying his porch, and they therefore had to have consent or a warrant to do the canine drug sniff on the front porch. So that's Florida versus Jardines. Again, at some point, you're going to leave that curtilage area and enter the open fields, and that's a case-by-case basis. Blind justice. Thanks for joining me. I hope you're a free man tonight. Is a judge's physical signature required on the warrant, or just a computer printed signature block? That's a good question. I don't know that I've read any federal law that specifically applies to that, because here in West Virginia, I haven't had that come up because it's a state statute that search warrants or arrest warrants have to be signed by a magistrate judge or a circuit judge, and they have to be signed in person, and they actually have forms for it. So it hasn't come up in my state. And I would suspect that every state probably has some sort of state statute on the books describing how search warrants are to be issued. And so I don't know if there actually has been a federal case pertaining to the lack of an actual signature block. I can tell you, I have had a beef with the forms that they use here in West Virginia that just have a signature block and a date. So what I think the police officers were doing is they would illegally search a car or even a house. And if they find something, then they go to the judge and they swear out a warrant, and they get a warrant that same day. And so there's a signature on it and there's a date on it, but there's no timestamp. So therefore you don't know whether it was issued before the search or after the search. And I actually personally talked to several of the West Virginia Supreme Court justices about changing that form to include a date. It would be super easy the time. It would be very easy just to fill in the time so that we know, because that's crucial information. I mean, we need to know which came first. And if the defense lawyer doesn't ask it, or if the police officer lies on the stand, we don't know whether it actually was an illegal search or it wasn't an illegal search. Now, federal court, I can tell you, I don't do criminal defense in federal court, but as far as the civil side in federal court, it's all done electronically. So there are a lot of judges' signatures that are handed down electronically. So I don't know whether they will also do that with search warrants or not. And I wouldn't doubt it if they did. And then if there's a dispute about whether or not it's legitimate, then I suppose that can be handled within that particular case. Okay, so then if searches of the home without a warrant are presumptively illegal, therefore searches of a home by law enforcement with a warrant are likewise presumptively legal. So all searches of a home made pursuant to a warrant are per se legal, and then it's on you to prove that there was some deficiency there. So it's always a requirement that police officers must tell the truth when they seek out a warrant, and that's always done under oath. Therefore, if you discover that false information was provided to the judge who signed the warrant, that is one way to attack that warrant. So if you attack the warrant by the means of fraud or lies or omissions that cause that warrant to be kicked out, then you're back to presumptively unreasonable. So what is required to get a warrant in every state? Basically, probable cause. And what is probable cause? Probable cause is something that's determined by the totality of the circumstances. A judge is to make a quote, practical common sense decision, whether given all the circumstances that the officer set forth in his affidavit, that there's a, quote, fair probability that contraband or evidence of a crime will be found in a particular place. Now, that is Illinois versus Gates, 1983, U.S. Supreme Court. You see this language in pretty much all case law. There must be a nexus between the place being searched and the items sought to be seized, and that can be established by the nature of the item, using normal inferences where one would likely keep that sort of evidence. When there's a reason to believe that a person is unlawfully dealing contraband, drugs, the probability exists that he's keeping evidence of it where he resides. That's from a Fourth Circuit case, United States versus Grossman. But I suspect all the circuits have something similar. As we discussed, there are going to be state-specific statutory requirements for a warrant. Here in West Virginia, which is where I practice, search warrants, there are state-level requirements. And again, states are free to be more restrictive than and let me get this right. States are free to be more protective of your rights. They just can't be less protective than the federal baseline of Fourth Amendment rights. So they can give you more rights. They just can't take any of your federal rights away. So therefore, in certain states, there might be additional requirements here in West Virginia that in North Carolina, for instance, blind justice may not have. In West Virginia specifically, the requirements, I mean, they're not that big of a deal, but there must be a written affidavit detailing the probable cause and listing and describing the place to be searched and items to be seized. It then says under our state law that the warrant must be executed by the officer who obtained the warrant within 10 days of being issued. Now, that's West Virginia state law, and sometimes there's a requirement that they be executed during the daytime and not at nighttime. And again, a lot of that is state law. So you have to look at what the specific state statute says in your particular state and what say your state Supreme Court decisions have said interpreting that statute. Generally, under federal law, warrants can't be overly broad. So the scope of a lawful search is defined by what they're looking for and the likely places where they might find it. So probable cause to believe that a stolen lawnmower, for instance, may be found in a garage is not going to extend to the upstairs bedroom of the house. Probable cause to believe that illegal aliens are being transported in a van outside the house is not going to justify a warrantless search of a suitcase in the house. So warrants can't be overly broad. Maryland versus Garrison, United States Supreme Court, 1987 is the general case on that. So here's a question that I get asked a lot. Handcuffing. Can occupants of a house be handcuffed by police officers when they're executing a search warrant in the house, even if they're not under arrest and they're not suspected of having committed any crime? The answer is, unfortunately, yes. If your house is searched pursuant to a search warrant execution, law enforcement can handcuff you. There's quite a bit of case law on this. Some of the terrorism cases out of the DC circuit, I believe, and the Fourth Circuit have to do with the FBI and the Department of Homeland Security searching some of these suspected terrorist residents and keeping them in handcuffs for several hours, and they filed lawsuits. So there's several cases out there like that. So even if you don't think it's right, which I don't, they can handcuff you, and it's sort of up to officer discretion. So they also cannot handcuff you. And I've heard from people who told me their story about their house being searched where they were not handcuffed. But a lot of people were handcuffed, and even if there was no real legitimate reason to handcuff them, there was no evidence that they were violent, they hadn't made any threats, they had done nothing wrong. They maybe were just visiting the house. Unfortunately, under federal law, they're allowed to do that. And it's basically for the reason of officer safety. But like everything else, it's that old reasonable standard. where you just have to basically convince the judge that the officers overstepped. It wasn't reasonable. So what does that mean? There's not really a bright line rule as far as how long they can keep you handcuffed. But I can tell you that hours of being handcuffed have been upheld as constitutional as reasonable. It sort of depends on the circumstances. How big is the house that they're searching? What are they looking for? What you could even then extend to the behavior of the residents. Were they completely cooperative, or were they aggressive and telling them that what they're going to do when they unhandcuff them? So every case could be different. Another popular issue these days, also unfortunately, is the knock and announce requirement. So do police have to knock on the door if they search the house with a warrant? There is a default knock and announce requirement under our Constitution, though in my experience, it's frequently ignored. There's a 1997 case called Richards versus Wisconsin. That is the Supreme Court. And it held that before forcibly entering a residence, police officers, quote, must knock on the door and announce their identity and purpose. That's the knock and announce requirement. This is what people are talking about when they discuss no-knock entries. Do police have to knock, or do they can they bust in with a no-knock entry or a no-knock warrant? So this is a big area in the law right now. In order to justify a no-knock entry, the police must have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous or futile, or that it would inhibit the effective investigation of the crime by, for example, allowing the destruction of evidence. Basically, this is exigent circumstances. The Supreme Court has admonished that, quote, it's the duty of a court confronted with the question to determine whether the facts and circumstances of the particular entry justified dispensing with the knock and announce requirement. So it's very similar to the exigent circumstances requirement. But therefore, if they think that something is dangerous or a particular entry is dangerous, the law requires them to seek a no-knock warrant, seek permission from the judge prior to getting to the residence. And that's the proper way to do it. But the law does allow them to still do a no-knock entry if they get to the scene and they see something they didn't know before that has created some sort of exigency in their mind. Another big case that I've relied on here in the Fourth Circuit, and that's Virginia, West Virginia, North Carolina, Maryland, South Carolina, West Virginia, if I didn't say that. Fourth Circuit, that's where I practice. United States versus Kennedy. The knock and announce principle forms part of the Fourth Amendment reasonableness inquiry. They may be reasonable by virtue of, like I said, exigent circumstances, but the facts must be particularized. So courts have upheld no-knock entries where the police officers have been able to articulate why this particular house would be dangerous to knock and announce first, or this particular resident or occupant of the house would be too dangerous to knock and say, hey, we're the police, open up. They have to be able to articulate to judges why that would be too dangerous, why they would be likely to be shot, or whatever the case may be. They can't generally just say, well, this guy was a suspected drug dealer. Drug dealers are dangerous, therefore we didn't knock and announce. That's what's not allowed. It has to be particular information about these individuals. Here's another interesting question which popped up in the Fourth Circuit is, what if the homeowners have concealed weapon permits? Obviously, police officers, if they want to, can access that information. If they're going to search a house, they can tell whether or not the occupants or the residents of the house have concealed weapon permits. Can they say, since you have a concealed weapon permit, therefore logic dictates that you have firearms, and firearms are dangerous and scary, therefore it would be way too scary to knock and announce, and we're just going to do a no-knock entry. Well, it could be the U.S. Supreme Court hasn't addressed this situation, But the Fourth Circuit did in a case from 2011 called Ballot versus Edwards. And the court held that the bare fact that homeowners have a concealed weapon permit cannot itself justify a no-knock entry into that house. And there was actually some good language by the court in that case, such as, quote, "We think a reasonable officer would have known that guns do not fire themselves, and that a justifiable fear for an officer's safety must include a belief, not simply that a gun may be located within a home, but that someone inside the home might be willing to use it." So the Fourth Circuit requires actual articulation of why this person is dangerous, not just why he may be armed. The court continued, while in some cases a no-knock entry may prevent violence, in other cases an unannounced entry may provoke violence in supposed self-defense by the surprised resident. And that's exactly why I oppose no-knock entries. And that's from Hudson versus Michigan. That's from a 2006 Supreme Court case. Again, Hudson versus Michigan. While in some cases a no-knock entry may prevent violence, in others an unannounced entry may provoke violence in supposed self-defense by the surprised resident. So it's a double-edged sword. And the Fourth Circuit cited that case and said that this double-edged sword underscores the need for the particularized suspicion requirement that this resident would resort to violence when police knock and announce their presence. The court further held, and this is all, I've used all this language before in my own no-knock warrant case. That's why I have it all written down. But it's great Fourth Amendment language to quote. And again, this is Bellott, Bellotte versus Edwards from the Fourth Circuit, and it could be used anywhere. A lot of times I'll cite a Sixth Circuit case or a 10th Circuit case or a First Circuit case if there's not a case on point here in the Fourth Circuit. So it's a great case. They also said to permit a no-knock entry on facts this paltry, this is the CCW case, would be to regularize the practice. Our cases allow officers the latitude to effect dynamic entries when their safety is at stake, but the Fourth Amendment does not regard as reasonable an entry with echoes, however faint, of the totalitarian state. And that's just a great quote to insert into a brief to a judge to really drive home that these guys are totalitarian tyrants. And I've had good luck with citing that case. I love cases like that where the judges really get, in the spirit of our founding fathers, and they really get into the Constitution. All right, so if there were additional facts, if we take the same CCW couple, if the officers were to allege other facts in addition to that, it could have been a good no-knock entry, such as the specific criminal history of one of the occupants. So did he have a conviction for a violent offense in the past? Did he shoot at somebody in the past? Or what is the crime that he's suspected of? In the Bellott case, it was a child porn allegation. And that, the court held, didn't have anything to do with the tendency of them being violent if police knocked on their door. Now, believe it or not, the cops argued that because child porn is going to land them potentially in prison, most people would want to avoid that. Therefore, they might react with violence. And the court said, no, that's absurd. You have to have specific information about why these people might be dangerous. We don't want generalities. So here's two examples that the court used that I think are good examples for when they're justified under the law and when they're not justified. So one case where they're not justified, this is from a 2006 case in the Fourth Circuit, United States versus Singleton. So this is what the cops alleged in that case. A drug dealer with previous firearm offenses located in a known drug area, but without any more particular specifics. The court held that was not justified. It wasn't specific enough as to the individuals. Contrast that with United States versus Groggins, Fourth Circuit, 1998. This was found to be justified. This was alleged to be a drug dealer with a violent history of shootouts, managing drug operations and intimidating people by firing weapons into their home, and who also said that, quote, he was not going to go back to jail and that he would do whatever is necessary to avoid it. So that was found to be justified. Just calling the guy a drug dealer, and drug dealers are dangerous, even combined with prior firearm offenses, was found to be not enough. All right. Earl Blackman. In an apartment complex with a warrant search, why office just get a key to enter the apartment? All right. So I think your question is, in an apartment complex, why can't they just get a key from the manager of the complex to enter the apartment? I'm glad you asked that question because I have an answer for you. I have an answer as to why they can't do that. Now, some of them do that because a lot of cops have no idea what the law is. And there are some in West Virginia who've tried to do this, and they have no idea that the Supreme Court said you can't do that all the way back in 1961. So can a landlord consent? And that's what the question is. Can a landlord consent to the search of his tenant's residence, whether it's an apartment complex or just a landlord for a house or even a hotel room? No. Chapman versus United States, U.S. Supreme Court, 1961. A landlord cannot give you permission, if you're a cop, to search his tenant's home or his apartment for illegal stuff. Can't do it. The protection of your house extends to apartments that you rent, rented rooms within a house. It extends to hotel rooms so that a landlord may not give the police consent to conduct a warrantless search of a rented apartment or room. So what do they need to do? If they want to search it, they still have to go get a warrant. They can't get around the warrant requirement by saying, well, he's just a renter, he doesn't own it. We'll just get the landlord's permission. And even if the landlord has a lease that says we can go in and inspect anytime we want, that still does not mean that they can authorize the sheriff's department SWAT team to go in to search the house, because that is not the tenant going in to see if the water's dripping. That's a great case to read, Chapman versus United States. It's happened back in 1958 and had to do with moonshiners down in Georgia. So basically, these guys had rented this landlord's house in Georgia, and he really didn't see him there. And he was getting suspicious every time he came to knock on the door to meet these guys. There was no one there. The landlord noticed that there was this smell of possibly mash coming from inside of the house, and there appeared to be no furniture in there when he looked in the windows. So it was kind of obvious to him that they had an illegal distillery set up making moonshine. And so basically he called the cops. The cops arrived, and what they did is the landlord apparently didn't even have a key. So even with the landlord present, the police officer, I think, piggybacked off of the landlord and crawled in through an open window, and he waited for the tenants to come home. So the tenants come home, and all of a sudden they're met with a police officer in their rented house. And really it was just an illegal still operation. It wasn't really a house that they were actually living in. But the officer arrested him at that time. It went all the way up to the Supreme Court. And the Supreme Court had basically three problems with the facts in this case. One is that the police officer had forced entry by climbing through the window, which is ironically similar to a case that I have here in West Virginia. You may have seen the video of the drug task force searching my client's house, but that's for another video. Secondly, the Supreme Court found that the purpose of the officer's entry into the house was to search for the distilling equipment that they clearly could smell from outside the house. It wasn't to go inside just to evaluate the landlord's property to see if his house was okay or if it was flooding or something like that inside. Thirdly, if the Supreme Court were to allow this sort of intrusion to occur without a warrant, they held back in 1958 well, 1961 by the time it got to the court, but it happened in 58. But the Supreme Court held that if they allowed this, it would reduce the Fourth Amendment to a nullity and leave tenants' homes secure only in the discretion of landlords. And that would be a pretty crappy situation if your landlord could let the cops in anytime they wanted to without a warrant, and therefore without probable cause. And there was nothing that you could do. So you'd have every man's home would be his castle, except for all the poor renters out there. All right. Let's see, before I move on to the next topic. All right. I don't think there's any more on that specific topic. All right. So how do you attack a warrant? If you have a valid warrant, they search the house, they come in, there is a warrant. Is there anything else that you can do? Yes, there is, both as a criminal defendant or as a Section 1983 plaintiff in a civil rights lawsuit. You can attack the warrant. In fact, you have to attack the warrant. If you're going to sue for false arrest, for wrongful arrest, and you're arrested with a search warrant, you can't just say, well, I was wrongfully arrested with probable cause because I didn't do it. You can't say that because there's a warrant. And the officer can just say, well, I arrested you because there was a warrant. He was just doing his job. Therefore, if someone's arrested or searched with a warrant, you therefore, to sue or to get out of the criminal charge, you have to attack that warrant. Generally, these are referred to as Frank's claims. And this is out of the U.S. Supreme Court case from 1978 called Franks versus Delaware. And basically, false representations or omissions in a police officer's warrant application are Fourth Amendment violations and you can sue under Section 1983. And so that's why they're called Frank's claims. Just a quick question here. Uncontrollable. While on probation, you consent to whatever they say in the paperwork you sign. I clicked on your comment because that is a good point that I didn't mention, that one of the first questions I have for people that call me and say maybe the cops searched my house, they didn't have a warrant, is one of the first things I probably want to know is, well, are you on parole or probation or sex offender supervision, something like that? Because if you are, then you actually have, unfortunately, less Fourth Amendment protections than the rest of us do. So somebody that is on parole, for instance, and that depends on the state, in exchange for you being out of prison, which they're allowed to put you right back in prison, you've agreed to take a drug test randomly or let them search your house randomly. So you've given up certain rights. And that also, to the same extent, is allowed with probation. Now, I had a case I took all the way to jury trial for a guy who was a registered sex offender. And there were other people other than him living in his house, his wife, and they had kids. But basically, he was on this extended supervision for registered. No, he wasn't. What was that case? That was a different. I've had a couple of these. The one we tried, that guy was a registered sex offender, and that's what it was. The West Virginia state law said they have to come to your residence once per year to see if you're actually living at that address. And that's what the statute said. It didn't say search. So what the cops were doing is, since the statute said that, they figure, all right, if we're coming to check and see if you live at the residence, we can just go ahead and search your house too. So they searched this house, and they searched it up and down. And they had another reason unrelated to the sex offender registry why they wanted to do it. So we ended up trying that case at jury trial. And, again, these are judged on a factual basis, and we ended up losing. And the problem is people, they're hesitant to protect the rights of somebody who's a registered sex offender. And they're much more likely to say that the police officer did nothing wrong. So that's the kind of the harsh reality of trying to enforce the Constitution, is that a lot of your potential jurors won't protect the constitutional rights of somebody that they just don't like because they're a registered sex offender or they got convicted of some other crime. But yeah, probation, sex offenders, sometimes parolees, and even people on bond, anyone they could have in jail otherwise, they can a lot of times come and search their house without a warrant. So that's not really what we're talking about here, but there could be other facts like that that give somebody a lowered level of rights. Road Trip Eddie, it's just best to be a good person in society, to help others and do what's proper, ethical, moral, and right. Well, that's true. That's true. But it's also been said that, he who would make his own liberty secure must guard his enemies from oppression. For if he violates that duty, then he establishes a precedent that will reach to himself. And that was Thomas Paine from 1795. And that basically means, as he said, that if you don't even protect the rights of people you view as your enemies, you won't have those rights yourself. And that's the most difficult thing to explain to people, especially at a jury trial, is why you should care for this unsympathetic client who had broken the law or had done something to encounter the police to begin with. A lot of people's knee-jerk reaction is just to say, "Oh well, if you don't have to worry about it if you don't break the law," and we know that's not true. I mean, you can look what the FBI had done to President Trump, to other people in his cabinet. If they want to come after you, they will. Look what they did to General Flynn. It's not just if you have something to hide. There's 5,000 plus federal laws. There's thousands more state laws in every state. If they want to get you on something, they can get you on something. So back to Frank's claims. So attacking a warrant. If an arrest is made without a warrant, if an arrest is made with a warrant, or if a search is made with a warrant, then you have to attack the warrant. So how do you succeed? Well, to succeed, you have to prove that the police officer, when he got the warrant, and this is specifically, a lot of this is, this is all Supreme Court stuff, but I'm quoting a Fourth Amendment case here that I use. But plaintiffs must prove that the police officers, quote, deliberately or with reckless disregard for the truth, made material false statements in their affidavit asking for the warrant, which were necessary to the judge's finding of probable cause. Or they can show an omission by showing that material facts were withheld from the judge with the intent or reckless disregard of whether they forgot them, to make the affidavit to the judge misleading. So they lied about something, or they withhold information about something that was really important. Now, to determine whether it's really important, this is the standard. A court must excise the offending inaccuracies and insert the facts that were omitted. So the court can still fix the problem and see if there's still probable cause. So the court can take out the false stuff, they can insert the omissions, and then they determine whether or not this corrected warrant would establish probable cause. And if it does, then there's no civil liability against the officer. So what is reckless disregard? That can be established by evidence that an officer acted with a high degree of awareness of a statement's probable falsity, meaning that an officer had serious doubts as to the truth of his statement or had obvious reasons to doubt the accuracy of the information he reported. Reckless disregard can be established by evidence that a police officer failed to inform the judge of facts that he knew would make the judge not want to grant the warrant because there was no probable cause. So we're not talking about innocent mistakes. We're talking about purposeful, intentional conduct. And this is a very difficult standard to make, very difficult. In fact, I've only seen this done one time, and I was the person who did it. Let's see. Let's see. Oh, the other thing, qualified immunity. That doesn't apply in a criminal case. So it doesn't come up in the criminal defense context. But if you're like me, you're filing a civil lawsuit, Section 1983, even if you prove all that stuff I just said, they can still give the police officer qualified immunity. However, if he acts intentionally or recklessly, if he intentionally lies to the judge or hides something from the judge, violates the Constitution, then there is precedent that qualified immunity should not apply, but it still is going to be an issue. But the judge could deprive, it's going to be up to the judge. They could deprive the officer of qualified immunity. Now, the case I had, the officers did get a warrant from my client's house. They did find a bunch of heroin in the house. So they had guessed right about what they would find in there. But in order to get the judge's signature on the warrant, they said stuff that wasn't true. They said they saw something they didn't see. They said somebody said something that they didn't say, and they got called on it by a federal judge in the criminal case. He said, now, wait a minute. The evidence shows that all these things that you said to the judge who signed the search warrant aren't true. And even though you did find heroin in there, you didn't actually have probable cause when you got the warrant. So it was a good guess, but you lied to get the warrant. And the entire criminal case was thrown out in that case. This was the Sizemore case. This was out of Fayette County, West Virginia. And so I was brought this court order from a federal judge saying that these police officers lied to get a warrant and throwing the warrant out. And the criminal charges went bye-bye, basically. So I filed a civil lawsuit for an unlawful, unreasonable search and seizure. And we really got a great opinion from Judge Goodwin in the Southern District of West Virginia, just hammering the police officers, or at least one of them, and denying him qualified immunity. And so that's a great opinion. It is to look up the Sizemore versus Morris opinion from the Southern District of West Virginia, handed down, well, I think it's 2019. And that's one of the only cases I've heard of where it was actually done and qualified immunity was withheld in the subsequent civil case. So I'm sure it's happened in other cases, but that's the first one that I've encountered. There are other Fourth Circuit opinions that I've gathered on these warrant challenges. So what about sloppy police work? So the laws might be slightly different, whatever circuit you're in. But a lot of these have to do with the defense of sloppy police work. Is that a defense? Yes, unfortunately, sloppy police work may be okay. It is in the Fourth Circuit, generally. So the failure to pursue a potentially exculpatory lead standing alone does not establish liability on the officer in the Fourth Circuit. That's the Clipper case. So even if they knew about potential exculpatory evidence and they didn't pursue it, that doesn't alone attack that warrant. Although an officer may not disregard available exculpatory evidence if he's actually aware of it, the failure to pursue just an exculpatory lead is not by itself sufficient. That's another case that's similar. That's the Smith versus Reddy case, also Fourth Circuit. And some of the other language that's been handed down, reasonable law enforcement officers are not required to, quote, exhaust every potentially exculpatory lead, resolve every doubt about guilt before probable cause is established. That's the Torchinsky case. So they're not required to include every piece of exculpatory information in the affidavit. And if they omit something, so long as they're not intending to mislead the judge and it's not an egregious case, generally sloppy police work will be found to be okay, which is unfortunate. There was one case in the Fourth Circuit where they even found that the omission of the fact that there were 6 eyewitnesses who failed to identify the criminal suspect in the photo array, even that didn't satisfy this Frank's test, absent the evidence that he had intention to mislead. So long as it was a stupid mistake or a sloppy mistake, then they get away with it. So you almost have to establish that they intended to mislead the judge. So it's very much It's kind of one of the few exceptions of the objective standard, where usually we're looking at the objective good police officer. Here, we're sort of allowed to look at the actual malice or intent of the police officer in doing something wrong. Somebody had asked about discussions with a prosecutor. I have several cases on that. There's one from 2000 in the Fourth Circuit called Watkins versus Arnold. And if a police officer confers with the prosecutor before seeking the criminal charges, that is a heavy fact that weighs towards finding that the officer is immune from liability, even if there was no probable cause in fact to charge. Found that mistaken legal advice by prosecutors given to police officers, that they can rely on that and get out of any sort of civil liability. But here's where they cross the line. What about lies or material omissions to a prosecutor? That's where they can get in trouble. So a law enforcement officer who presents all available evidence to a prosecutor generally is going to be okay. He's going to be insulated from a malicious prosecution lawsuit where the person was, for instance, in fact, innocent of that, or there was no probable cause to begin with. But they cannot conceal facts from the prosecutor if that's found to exist, or they can't misrepresent material facts or unduly influence the prosecutor. Now, what does that mean exactly? I'm not sure. And why would you be unduly influenced by a police officer if you're the prosecutor? I don't know. But apparently that's happened. That language comes up in a lot of different cases, at least here in the Fourth Circuit. What about grand jury testimony? I've looked at this many times. I've had people call me and say, I have evidence that a police officer lied before a grand jury and I got indicted. And I can prove it. And so maybe they have the transcript from the grand jury and they have the absolute proof. They can prove to me beyond any doubt that this officer lied. And he lied because he hates this person. It could be any reason. Unfortunately, the law says that absolute immunity is going to apply even to police officers who lie because they're a part of the grand jury process. So you look at all this stuff that's happened with the Mueller prosecutors and when they went after General Flynn and Roger Stone, and things that may have been presented, such as the Russia dossier, that were later found out to be false. And maybe these officers knew or should have known that they were false, these FBI agents or whoever they were, before they testified to this grand jury. Too bad. As far as civil lawsuits go, for anything that occurred before the grand jury, they have absolute immunity. So they have even better than qualified immunity. Basically, you can't sue them. I've looked at it. I've even tried. There's not a damn thing that you can do for lies before a grand jury. And so this might answer the question, if you've ever thought about it, why do all these prosecutors put a lot of these police shooting cases or excessive force cases before grand juries? Because everything that is said is completely, absolutely immune from any civil lawsuit if it turns out not to be true. And that's probably one good reason. Somebody had asked, I think it was Natalie, do they have a right? Do you have, as a homeowner, a right to see the warrant? That's a good question. I've had a lot of people ask if they have to show you the warrant, and a lot of times they don't. I believe that is a state law creature, at least here in West Virginia. I know there is a requirement that they have to leave a copy of the warrant, and they have to leave an inventory of anything that they took off the premises. And I believe that's under the West Virginia state statute governing search warrants. I don't believe that's a federal law. There might be a separate one for federal warrants, and there might be a separate state law in every state, or they might be similar. But in West Virginia, anyways, they don't have to show it to you first or even during. They just have to leave it with you before they leave, and they have to leave an inventory. Okay, America is not a republic or a democracy. It's an independency. All right. It's the first one I've heard about that. All right. Can someone please post with quotes where a citizen of the United States has any rights under the Constitution? I'm not sure I follow your question. Pretty much every quote in the Constitution applies to citizens of the United States. I guess I miss your point here. What happens, Daniel? What happens if a judge refuses to see evidence? Well, I don't know what context you're talking about. In the search warrant context, we don't really know what the judge is seeing or refusing to see. In the grand jury context, we're not dealing with a judge. You're basically looking at a prosecutor, grand jurors, and a court reporter. Now, in the criminal proceeding context, you're entitled as a criminal defendant to present evidence subject to the rules of evidence. So, everybody has a common rule book called the rules of evidence. And, if the judge doesn't allow evidence, for instance, to go to a jury that you wanted to present on your own behalf, that's something that you can appeal to the higher court after you get convicted. And prisons are full of people that are doing that at this very moment. Uncontrollable. What do you think about judges legislating from the bench? Well, I'm absolutely opposed to judges legislating from the bench, and that's a lot of the way that we got to the point that we are now, where each side thinks that they are entitled to a certain number of justices on the Supreme Court, as if there are sides. That's because one side in particular, the left, in the past however many years, has, since they couldn't win at the ballot box on a lot of issues, such as abortion, because they would never win. They would never win in the majority of the country on defeating abortion at the ballot box. But they were able to get the head of the ACLU, the head lawyer from the 70s, who argued the Roe versus Wade case, onto the Supreme Court, because she got the Supreme Court to legislate from the bench their favorite case, which is Roe versus Wade. So no, I'm not in favor of any sort of legislation from the bench. And it's always a problem whenever it happens. I'm an originalist. Okay. Some of the other issues around this are video footage. Nowadays people have Ring doorbells. I've dealt with those in several cases already. It's great evidence to have. You have these Ring doorbells or something similar to it, and a lot of times they'll have timestamps, and they'll show when the police officers first arrived, even if nobody is home. Video evidence is always very difficult to beat. There's a U.S. Supreme Court case from 2007 called Scott versus Harris that says even if the testimony of a police officer in a civil rights case is blatantly contradicted by what you see on the video, the court is allowed to go with the video and completely disregard what the police officer says. Now, that's more important in civil cases where judges can put to a jury, disagreements of facts, or they can decide the case themselves if they feel that there's not enough disagreement of facts for any reasonable jury to go in one particular side's favor. So, for instance, if there's a video showing a police officer punching a handcuffed guy in the face, and he gets on the stand and says, "No, I didn't do that. It looks like that. That's not really what it was." I mean, he's completely lying. The judge can completely disregard what that guy said, and he can hold, just by watching the video, as a matter of law, that this was an excessive force violation. And that's a good example, because I actually had that actual thing happen. I tried a excessive force case. This is back in like 2012 or 2013 that I had on video. And it showed my client being punched in the face, being choked and thrown down on the ground. He's left down on the ground. And we tried the case, and the police officers got on the stand, including the one who did it and the two that were in the room kind of watching. They all said, no, that's it. It's not a punch. It didn't look. I mean, it may look like a punch, but he really was going for a pressure point behind the ear. We were taught that in the police academy. And then the judge just knew it was complete bullshit. So he let it go to the jury to see what they were going to do. And so the jurors, in federal court, you have 8 jurors. They just didn't like my client. He had tattoos not only on his neck, but on his hands. And while you can cover up the neck, mostly you can put a turtleneck on him, there's really no good way to cover up his hands. And then it looks possibly even creepier if he's wearing gloves. So there was no good way to make him more appealing to the jurors. Here in West Virginia, we have a pretty conservative jury pool. A lot of country people, they're going to be very quick to support the police, and they're going to be very quick to condemn somebody who committed a crime. And they just have to be educated as to why it's important to protect all of our rights, because one day you might need those rights. And if you deprived it to this guy, that means the cops will be able to deprive it to you or your granddaughter or something down the road. So it's difficult to get them to see why they should do the right thing. And so they didn't in that case. And they ruled against us. We got a defense verdict, even though it was on video. So what the judge did, the federal judge, he throws out the jury verdict. And he finds, as a matter of law, that this was an excessive force violation because it's on video. And he wrote this great opinion that said, I'm reminded of the Groucho Marx Duck Soup movie, where she sees Groucho and he's wearing the fake nose and the fake mustache. And she says, I can tell it's you, Groucho. And he says, what? Who are you going to believe, me or your lying eyes? And it was exactly like that. So video is, if a judge wants to, they can run with it and they can use it as the deciding factor and even take it away from the jury. So that's how powerful video footage is. And so when you're in your home, you can have cameras up ahead of time. And as you may have seen in this other YouTube video I have, you can even have videos hidden inside your house that even if the police cut the wires on the surveillance camera outside, they won't know, hopefully, where the cameras are on the inside, and you'll catch all the footage, everything that happens. And if you get it on video, you got it. That's probably the most important thing, in my opinion, as a civil rights lawyer. If somebody is pitching their case to me, I can only take so many cases. I love something on video, because without video, the old saying is that there are 3 sides to every story. There's your client's side, there's the police's side, and then there's the truth. Somewhere in between, and you may not find out what the truth is, or you might find out what the truth actually is at the worst possible moment. And Murphy's Law likes to apply to those situations. For instance, I once had sometimes in the practice of trial law, we have these things called dirty little secrets. And you love to get a dirty little secret. And for instance, if you're defending these cases, what's their usual dirty little secret? Maybe they have a dash cam video with recording that was not turned over to you. And they withhold it. They withhold it until it wasn't on purpose, but it's withheld for whatever reason until the depositions come, till the client's depositions. And so then they put your client on the stand and they have him talk about everything that happened in the police car, for instance. All the threats that the police officers made, how they stopped the car and they beat you and all that. And then they pull out the laptop with the video showing that none of that was true. In fact, instead of the police officers punching your client in the face, it shows your client smashing his own head into the side of the car, threatening to harm himself so that he can sue you for excessive force. And that has actually happened, and that one has gotten a good laugh at some of the Section 1983 case seminars that I've participated in. And there have been other similar sort of funny, in hindsight, videos like that. But the point is that you can't beat video footage. And if you're watching this on YouTube, that means you probably already like police dash cam footage or surveillance footage at a home or business where something happens. I mean, you just can't beat it. See, any other questions here on specific issues? Interesting you mentioned Murphy's Law. Well, Murphy's Law, I guess, applies to everything, but when it applies in the practice of trying cases, then it really sucks. It really sucks, especially if you're a criminal defendant. Blind Justice was arrested as a passenger in a car in Madison, North Carolina that was on video and was BS. Yeah, Blind Justice was already here once. He asked a question. That's probably why he asked me the question the other day about whether a passenger of the car can be ID'd. And I think I answered that question, but I'll go back to that briefly if he's watching this, that generally under federal law, and he's in the Fourth Circuit with me here, that passengers can be ordered out of cars, and generally they can be ID'd, though the ID laws generally are state specific. I don't know what North Carolina's is. But a lot of times you have like obstruction statutes. So, officers are given a lot of leeway to ID people. I guess they can do it. The better question is what if you refuse? Then what happens? So if you're a passenger in a car, you're ordered out and you don't get out. And I think it's pretty clear they can order you out. I mean, if they order you out and you refuse to tell them your name or give them an ID, then probably they're going to look at state law first. Now, here in West Virginia, they have to have an actual reason to know your name. If you don't have your ID, they generally need to have a specific reason that applies to an investigation of why they need to know your name. Then they have to communicate that to you, and then they can possibly arrest you for obstruction for not telling them your name. But that, again, is West Virginia state law. And again, the state laws can be more protective. They just can't be less protective. Can they withhold the discovery until the day of trial? I've been told that it's routine not to see the discovery until the day of trial. I don't believe it's right. Well, fuck. I was a prosecutor in Raleigh, North Carolina, and we generally would try cases, misdemeanor cases, right then and there with no discovery. And that's the way it works in North Carolina, or at least it used to, that you show up, you try to work out a deal. And then if you can't work out a deal, you got to try the case right then and there, unless the judge allows it to be continued. There's no exchange of written materials. There's no written motions on misdemeanors. You just try the case right then and there, which is actually a lot of fun. So both sides talk to the cops and gets whatever police report they're supposed to provide. And actually, the good thing about it is if they don't show up or they don't bring the report, a lot of times you're done. I mean, you're not guilty. You get out of it. So now here in West Virginia, again, a lot of this is state law specific. So there's going to be different procedures for state criminal prosecutions. And it's going to matter if you're talking about misdemeanor or felony. Now, misdemeanor stuff, as I just said, depending on state law, they may not have to provide any discovery until the day of trial, the time of trial. Now, with felonies, it's going to be harder to do that because there are a lot more cases out there protecting the due process rights of criminal defendants. I would say no. If you're charged with a felony and you didn't get discovery up until the day of trial, I'm not saying it hasn't happened. I don't doubt that it has. That I think that's probably a problem, but that's generally going to be a creature of state law. I can't count how many people I've talked to who have pled guilty to felonies and never even seen the discovery from the state in their case because the lawyer never asked for it. And if they did ask for it or get it, it was never shown to them. Now, here in West Virginia, there is an obligation to provide discovery anyways, whether or not your lawyer asked for it. And I don't know if that's based on federal law or West Virginia law. Now, in civil rights lawsuits in federal court, pretty much every state, as far as I know, we have the federal rules of civil procedure for these federal lawsuits. There's something called Rule 26, And that's a mandatory disclosure of pretty much all the evidence you have, all the witnesses you have, all the exhibits you have before you even come close to getting to court. So it's the court makes you exchange evidence. Now, these are civil cases. That's not the same way in state court. If you're lazy in state court as a lawyer and you never ask for discovery, they never have to give it to you. Federal court on the civil side, you always have to exchange everything under Rule 26 very early on in the case, which is actually a great rule, great way of doing things. All right, so I guess follow up on this question. You've been denied the courts and your public defender entered evidence, or getting a motion of discovery is not in your due process to withhold your. That was a confusing question, but I think I already answered that question. Dan, am I familiar with Dale Carson, former FBI agent from Jacksonville, and his book Arrest Proof Yourself? No, I haven't read that, but that I can recall anyways. But I will definitely take a look at it. Jimmy Touchdown, actually, if you look at the last question, that might be a good reference book. I haven't looked at it, but Arrest Proof Yourself. I've been putting together a book when I have time of just things that I've gathered that I was going to call, Freedom is Scary, a citizen's guide or a patriot's guide to general constitutional laws you should know about. And I still might do that. The problem is finding the time to do it, but I'm sure there are others out there. You're taking News Now is taking screenshots to prove what comments have been blocked. Well, I don't have a moderator moderating comments, so I haven't blocked any comments. So take your screenshots away. No comments have been blocked to my knowledge, unless YouTube is censoring my comments. I don't know. All right, still the same thing. Why are you blocking out so many of my comments? And you say you're a civil rights attorney. I haven't blocked out any of your comments. In fact, I just put 2 of them up on the screen. Civil Rights Act 1964, religious accommodation for mask wearing. Well, don't get me started on the mask issue. In case you don't know, I'm currently suing the governor of West Virginia in federal court, challenging the mask mandate. So I could go on for another couple hours on the tyranny of all the COVID stuff and the mask mandate. But I don't want to start that. Bent Bow, our rights do not come from the Constitution. Fair point. Our natural rights preceded our Constitution. They were incorporated into and memorialized in our Constitution. But I certainly believe in the concept and that we do have natural rights. So I hear what you're saying. Hello from India. Well, I'm glad somebody's watching from India. Let's see, Alan Fisher, citizens' safety should come up before police safety. The police sign up for a risk-filled job. The public do not sign up for risk caused by cops who sometimes shoot before ensuring a risk is present. Absolutely. I mean, and technically, I mean, if their job is to serve and protect, and they're actually there to protect us, then why is it okay to put our safety below their safety? I've told this story before, but in a case I litigated having to do with a no-knock entry without a no-knock warrant that basically scared my elderly client to death as he was watching TV sitting on his couch, and they busted in with a SWAT team with machine guns, literally, it stuck in his face. He died while short of breath, and he was handcuffed, and he was begging the police officer to take the handcuffs off. And when I asked the police officer in his deposition under oath, why didn't you take this guy's handcuffs off? I mean, he said he couldn't breathe. He said, well, and this guy, mind you, was standing there in armor at the time. I mean, he's got the entire SWAT team suit on. He said, well, we were in a kitchen. I mean, he could have went and grabbed a kitchen knife and stabbed me to death. Now, this guy's standing there in armor with an obviously unhealthy elderly man who's having trouble breathing, and this guy isn't even under arrest. He just owned the residence. He hadn't done anything wrong, but yet we're going to let him, die in handcuffs because he couldn't breathe, just because we could be stabbed. I mean, it reaches absurd proportions in many of these cases. Said Mac, can a federal magistrate dismiss a lawsuit because I sent a copy of interrogatories and a request for discovery to the courts as well as defendants? Okay, so you're litigating a federal civil case pro se, which means you don't have a lawyer. So it's possible, but there's going to be a lot of ways for you to screw up. Now, screw up number one, generally in those types of cases, maybe they force it when it's a pro se case. I don't know, but I've never given a federal magistrate the opportunity to dismiss one of my lawsuits, because I always click the box on the forms when you first file the case and you first do the court's scheduling order that no, I'll choose the option not to allow a federal magistrate to take over and dismiss my case. I make the Article 3 real federal judge preside over the case, and you have that option as a lawyer anyways. I don't see why you wouldn't as a pro se litigant. But no, I don't leave it up to the magistrates. I'm sure a lot of them, they do a lot of discovery disputes, and I try to stay out of discovery disputes, but they do a lot of good decisions in discovery disputes, but I've never given one an option of dismissing my lawsuit. I always try to get to a jury, give the jury the option. And so the real Article 3 federal judge will have the opportunity to allow it to a jury or not allow it to a jury. They're sort of the gatekeeper. But yeah, you should have kept it before the actual judge and not the magistrate, because a lot of times they have these magistrate judge positions because of all the pro se lawsuits from prisoners and things like that, who they just sit there and file lawsuits all day, or the jailhouse lawyers lawsuits. And so the magistrate judges, I think they specialize in getting rid of pro se litigants' lawsuits. But as to your question about sending copy of interrogatories and requests for discovery to the courts, I'm not sure exactly what that means, but you would send those to the other party, not to the court. But you don't need to, as I just explained, generally in federal court, because under Rule 26, you already have to provide everything you have, all your exhibits, all your evidence, to the other side. Now, maybe they don't make that easy on you if you don't have a lawyer. I've never had that experience. Cops are not responsible for your safety. That's correct. They're not responsible, according to the U.S. Supreme Court. They don't owe you any legal duty to protect you. And as we've seen on TV this year, we are responsible for our own safety. Oh no, not mask mandate question. What is your theory on how the mask mandates are unconstitutional? Specifically, it's unconstitutional because the governor is not a lawmaker, or because arbitrary and capricious. Now, I don't know if you're in West Virginia. I assume so. But I've done several videos on this. But in West Virginia, the governor has enacted the so-called mask mandate without the legislature. Our legislature doesn't go into session until February of 2021. So under our Constitution, it says it'll never be suspended, even in a time of war. Therefore, in time of COVID-19, which has caused less deaths in West Virginia than the flu or even suicide, the governor cannot just declare himself a dictator and pass new laws. That's what the Constitution says. So in my opinion, it all comes down to not arbitrary and capricious, because I don't think he has the right to be arbitrary and capricious. It all comes down to separation of powers. Separation of powers is very important in the system of government that we have as a constitutional republic democracy. Democratic, what is it? It's probably a constitutional republic more than it is a democratic republic, but it's a tricameral form of government. And that's what our federal constitution provides for, and that's what our state constitution in West Virginia provides for. And it does not allow one man, a governor, to pass new laws, to create new laws by himself. And that's defined as tyranny by our founding fathers. I don't think they ever get past that on constitutionality. I think there's no way past it. There's no way past it at all. Now, convincing some court to do something about it is something different. They may try to say that emergency powers allow it, but they can't, because the legislature cannot give a power that it does not possess. It does not possess the power to amend our Constitution by statute. If they want to amend our Constitution, allow the governor to rule over us in any way he deems fit during a pandemic, then they can do that by enacting a constitutional amendment, which has happened several times here in West Virginia. So it's very simple for me. He needs to call the legislature into session and let them pass a mask mandate. And then we can challenge the legislature's actions. But it should be very simple to challenge the governor. He doesn't make laws under our Constitution. The governor has the authority over the administrative branch, no authority over private businesses or people. That's absolutely right. Bent Bow, Samuel Adams quote, "I firmly believe that the benevolent creator designed the Republican form of government for man." And there's so many good quotes from some of our founding fathers and some of the minds that we've had in this country back when we did have critical thinking as something that was valued in this country, back before the iPhones and all that. One of my favorite authors was C.S. Lewis. And there's a good, I've already got it here, C.S. Lewis quote, which I really love. And it's basically, beware the do-gooders. And he said this: "Of all tyrannies, a tyranny sincerely exercised for the good of its victims may be the most oppressive. It would be better to live under robber barons than under omnipotent moral busybodies. The robber baron's cruelty may sometimes sleep, his cupidity may at some point be satiated, but those who torment us for our own goodwill torment us without end, for they do so with the approval of their own conscience." And that's C.S. Lewis. And I think that's a good place to head back to the ranch and have a drink and a cigar. So I'll close by saying this, that look, let us defend ourselves here with freedom. Why is freedom scary? Because it's through the guise of safety, as C.S. Lewis discussed, that we, the people, lose our liberties and we lose our freedom. William Pitt the Younger said that necessity is the plea for every infringement of human freedom. It's the argument of tyrants. It's the creed of slaves. So don't forget to subscribe if you're on YouTube for more updates, more videos. Don't forget to subscribe on the blog website at thecivilrightslawyer.com. I appreciate you watching, and check out our pending cases at the website and on our YouTube channel. And until next time, again, I'm West Virginia civil rights lawyer John Bryan.
Come on.